Good morning to all of you. This video is for the final year students, professional ethics. Why I am making this video is, please remember the relationship between the client and the advocate is fiduciary, that is trustworthy. You have to maintain the trust. And also rule 15, I told you that you have to protect the interest of the client. You should not do anything which goes against to the interest of the client. So please remember, one such case, old case law has come to my notice. That's why I am making it to you. So this case is JohnD'Souza versus Edward Annie. JohnD'Souza versus Edward Annie, 1994. Right. So Edward Annie is the advocate, then JohnD'Souza, he is the complainant in this case. Actually, it relates to professional misconduct, section 35 of the Advocates Act, right? So JohnD'Souza is the advocate. He is practicing as an advocate since 1942. So actually, Edward Annie's father, he has drafted a will. So actually this will was drafted by our advocate person, and actually he died. That person's name is Mr. Mary Raymond, right? So after drafting the will, it was entrusted to the advocate for safe custody. Then after death, then only the will, power of the will come. So there was a dispute between father-in-law and the sons. So many disputes have taken place. Edward Annie, he claims to be owner of the property as per the interest, as per the will by his father-in-law, things like that. Now the main point is, the will has to be proved. Yes, definitely the court will ask you to prove the will, is it not? Right. So at that time, the client, Mr. Edward Annie, stated that it is with the advocate JohnD'Souza. Okay, agreed. Now, when the matter was entrusted, of course, when the advocate was asked to give the so-called the will executed, and the will which was entrusted to him for safe custody, but he refused to return that will. Right? Even though the client has written 2 letters, but he did not hand over the will. Will it not amount to misconduct? Definitely it will amount to misconduct. Very recently, no doubt with good faith, very recently I came to know a case where the proprietor of a cloth shop, he has entrusted the partnership deed to his chartered accountant while preparing the that is income tax returns. And okay, he said, okay, Baba, chartered accountant, you please keep it with you. If necessary, I will ask you. There is no much necessity for me now. But he died due to corona. His family, now they are fighting for the partnership in that shop. So now they asked the chartered accountant to give the so-called to give the partnership deed, for which he refused. Now the matter has gone to the court, and they have filed an interlocutory application, and the court asked this man to come and produce the so-called partnership deed along with the income tax returns, like that. Definitely they will be asking. So please remember, so here the will was written by Mr. Raymond, and during his lifetime, actually his wife is drafted the will and kept it with the advocate. Later the son-in-law, so that is Edward Annie, claimed to be the owner, and he asked the advocate to give it, but in spite of 2 letters written by him, no reply came from the that is JohnD'Souza advocate, and when he personally approached, the advocate refused to return the will. Now the Edward Annie, he filed a complaint with the Karnataka State Bar Council, of course, Karnataka State Bar Council, and action was proceeded. That is disciplinary committee under section 35 of the Advocates Act. They started their inquiry, and actually during the inquiry also, it was proved that actually this advocate rejected the complaint. So how can the man keeps the will with me, he has argued. But the client was able to prove that his father-in-law and the mother-in-law, they kept it with him. They told him on number of occasions, like that he was able to prove. So definitely the matter went up to the level of the Supreme Court also. Supreme Court, please remember, held that it is professional misconduct. So keeping the will, keeping the income tax returns, or sometimes keeping the file also. So already DC section or some case I told you. So keeping the file and without hand, you may be knowing the complainant or the client has got a chance to appeal to get the case argued by so many vakils he likes. So when he doesn't want your so-called wakalat, you have to hand over the file. If you demand money for hand over the file, it is also amounting to misconduct, right? So this is a clear case of misconduct. In this case, please remember, number one, the will was executed by the advocate, was drafted by the advocate, it was handed over to the advocate, it was in the safe custody of the advocate, but when the dispute came regarding to produce or to mark the will, this man has not replied. Maybe he might have asked for some money. Actually, in that case, that money matter is not there. Anyway, not handing over the will also will amount to professional misconduct. This much if you learn, it is sufficient. Thank you very much.